My Lords, at this late stage in any debate, I think much of the field is likely to have been covered. But as someone deeply involved in the crafting, drafting and the evolution of the EU GDPR, whilst an MEP in Brussels, I declare a strong vested interest in this subject. I would like to just hope that the Minister will in fact not be too negative about the work that we did, much of it done by Brits in Europe, on producing the GDPR in the first place. I raised this issue at the recent UK-EU Parliamentary Partnership Assembly and in bilateral discussions which I had with the European Parliament's Civil Liberties Committee, on which I served for many years, on their recent visit to London. But, my Lords, let me be candid. While the GDPR stands as a significant achievement in my view, it is not without need for enhancement or improvement. The world has undergone a seismic shift since the GDPR's inception, particularly in the realm of artificial intelligence. Both the UK and the EU, my Lords, need to get better at developing smart legislation. Smart legislation is not only adaptive and forward-looking, but it's also flexible enough to evolve alongside emerging trends and challenges. And the importance of such legislation is highlighted by the rapid advancement in various sectors, particularly in areas like artificial intelligence, so well referred to by my noble friend Lord Holmes of Richmond a little while ago, and how our data is used. These fields are evolving at a pace that traditional legislative processes struggle to match. Such an approach is vital not only to foster innovation, but also to ensure that regulations remain relevant and effective in a swiftly changing world, helping to maintain our competitive edge whilst upholding our core values and standards. The aspirations of this bill, aimed at modernising and streamlining the UK's data protection framework, while upholding stringent standards, are indeed laudable. But, my Lords, I regret when my noble friend Lord Kamal was speaking about cookies, I was temporarily out of the chamber enjoying a culinary cookie for lunch. And while there may be further advantages to be unearthed in the depths of this complex legislation, so far, my Lords, the biggest benefit I seem to have seen from the bill is its commitment to removing cookie pop-ups. However, above all, we must tread carefully to ensure international compliance, which has been referred to by a number of speakers, steadfastly adhering to the bedrock GDPR principles. Those principles, my Lords, were lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, and citizens' redress. And on a procedural note, and following other speakers, my Lords, the government's recent flurry of amendments, I think it was 266 in total, including 38 new clauses and 2 new schedules, a staggering 240 of them were brought in at the 11th hour, places a key duty on our House to meticulously scrutinise the new legislation line by line. I've already heard from other speakers reference to my friend, the Right Honourable Member for Halton, Price and Howden in the other place, who astutely observed that, in effect, that House has delegated large parts of the work on this important bill to the House of Lords. I have to say, my Lords, that's wonderful, because those of us who are always arguing that this is the House that does the work, that is an acknowledgement of the skills and powers of this House, and it really is most welcome as a reference. I wish to draw the House's attention briefly to 3 important terms: adequacy, that you've heard about, equivalence and approximation. Adequacy in data protection primarily comes from the EU's legal framework. It describes the standard that non-EU countries must meet to allow free flow of personal data from the EU. The European Commission assesses this adequacy considering domestic laws and international commitments. The UK currently benefits from the EU's 2 data adequacy decisions, which I remind the House are unilateral. However, we stand on the cusp of a crucial review in 2024, where the Commission will decide the fate of extending data adequacy for another 4 years, and the Commission has the power, my Lords, to withdraw its decision in the meantime if we threaten the basis for it. This bill must not increase the risk of that happening. Equivalence, my Lords, in the realm of data protection signifies that different systems or standards, while not mirror images, offer comparable levels of protection. It's about viewing a non-EU country's data protection laws through a lens that recognises their parity with GDPR in safeguarding personal data. Past EU adequacy decisions have not demanded a carbon copy of laws. Rather, they seek an essentially equivalent regulatory landscape. And, my Lords, approximation. This refers to aligning laws of EU member states with each other. In data protection, it could describe efforts to align national laws with GDPR standards. My Lords, the imperative of maintaining data adequacy with the EU cannot be overstated. In fact, it has been stated by many noble lords today. It stands as a top priority for UK business and industry, a linchpin in law enforcement cooperation, and a gateway to other vital databases. The economic stakes are monumental for both sides. EU personal data-enabled services, exports to the UK have been worth approximately £42 billion in 2018, and exports from the UK to the EU were worth £85 billion. I commend the Government for listening to concerns that I and others have raised about democratic oversight and independence of the Information Commissioner's Office. The amendment to Clause 35, removing the proposal for the Secretary of State to veto ICO codes of practice, was welcome. This move has, I am informed, sent reassuring signals to our friends in Brussels. However, a concern still remains regarding the UK's new ambition for adequacy partnerships with third countries. In the Government's impact assessment, it lists the United States, Australia, Republic of Korea, Dubai International Finance Centre, Singapore and Colombia, with future agreements with India, Brazil, Kenya and Indonesia listed as priorities. Some of these nations, my Lords, have data standards that may not align with those of the EU, or in fact offer fewer safeguards than our current system. I urge extreme caution in this area. We do not, my Lords, want to be in a situation where we gain a data partnership with Kenya but jeopardise our total data adequacy with the EU. Fundamentally, my Lords, this bill should not weaken data protection rights and safeguards. It should ensure transparency in data use, decision-making, uphold requirements for data processors to consider the rights and interests of affected individuals, and, importantly, not stray too far from international regulation. I urge my noble friend the Minister and others, adopting a policy of permanent dynamic alignment with the EU GDPR is important. Engaging actively with the EU as a partner, not just implementing new rules blindly. Protecting and strengthening the UK-EU data partnership offers an opportunity here for closer cooperation, benefiting businesses, consumers, and innovation and law enforcement authorities. And together, we can reach out to others with encouragement for them to join these truly international standards.